Today on Bench Briefs, we're looking at an important federal court of appeal decision that deals with the delicate balance between protecting refugees and the government's authority to enforce immigration laws. The case is Slepcsik vs. Canada, Citizenship and Immigration, decided in 2026, and it explores when and how courts should grant stays of removal orders for refugees facing deportation. So, what's this case all about? Mr. Slepczyk is a recognized refugee in Canada who found himself caught up in removal proceedings initiated by Citizenship and Immigration Canada. Even though he had refugee status, the government sought to remove him from the country. While these removal proceedings were ongoing, Mr. Slepczyk asked the court for a stay of the removal order. Essentially, he wanted the court to pause his deportation until the related immigration matters were fully resolved. This request brought up some tricky questions. Should the federal court of appeal grant a stay in this context? What factors should the court consider before deciding to halt a removal order? The case forced the court to clarify the legal standards that apply when a refugee challenges removal and seeks to remain in Canada temporarily during the immigration process. Let's break down the key facts. Mr. Slepczyk was recognized as a refugee, which means Canada acknowledged he faced serious risks if returned to his home country. However, despite this recognition, Citizenship and Immigration Canada initiated removal proceedings against him. These proceedings are administrative processes where the government argues that a person should be deported, often due to new information or concerns that arise after refugee status is granted. While those removal proceedings were underway, Mr. Slepczyk asked the court for a stay of the removal order. A stay is basically a legal pause button. It stops the government from carrying out the removal while further legal questions are sorted out. The issue was whether the federal court of appeal should grant this stay pending the final outcome of related immigration proceedings. The court had to carefully consider the timing and appropriateness of granting such a stay. On one hand, the government has a strong interest in enforcing removal orders to maintain the integrity of the immigration system. On the other hand, refugees have fundamental protections under Canadian and international law, and removing someone prematurely could put them at serious risk. The legal question boiled down to what is the correct test for granting a stay of removal in this refugee context? The court reviewed past principles and confirmed that the usual test involves assessing whether there is a serious issue to be tried, whether the applicant would suffer irreparable harm without a stay, and where the balance of convenience lies. In Mr. Slepczyk's case, the court had to decide whether his circumstances met these criteria. Was there a genuine and serious legal question to be resolved in his immigration proceedings? Would his removal cause harm that could not be fixed later? Okay? And did the balance of convenience favor pausing removal until the legal issues were settled? The Federal Court of Appeals decision clarified how courts should approach these questions. It emphasized that stays of removal are exceptional remedies, not granted lightly. Courts must carefully weigh the risk of harm to the individual against the public interest in effective immigration enforcement. The decision also highlighted the importance of timing. A stay should not be used to unduly delay removal proceedings, but must be available when serious legal issues and potential irreparable harm are evident. Why does this case matter? It underscores the ongoing tension in Canadian immigration law between protecting vulnerable refugees and ensuring that the immigration system functions efficiently and fairly. By setting out clear guidance on when stays of removal are appropriate, the Federal Court of Appeal helps both refugees and the government understand their rights and responsibilities during removal proceedings. This decision also reinforces Canada's commitment to upholding refugee protections, ensuring that removal orders don't lead to premature deportations that could endanger lives. At the same time, it confirms that courts will not act as a backstop to indefinitely delay removal without good cause. The ruling strikes a careful balance that respects both humanitarian concerns and the rule of law. So, to sum up, Slepczyk vs. Canada is a significant case that clarifies how and when courts can pause the removal of refugees pending ongoing immigration proceedings. It reminds us that while the immigration system must be respected, it must also protect those who face real risks if sent back to their countries. Thanks for listening to this episode of Bench Briefs. Be sure to join us next time for another deep dive into the latest and most interesting cases shaping Canadian law. Until then, take care.